Good morning to everyone. This is April 25th, 2023. This is Cannabis Compliance Board meeting. First order of business is our roll call to make sure we have an official quorum.
Member Merritt,
Present.
Member Durrett,
Here.
Member Young,
Present.
Member Guzman Fralick,
Present.
and Chair Douglas.
Here we have a quorum. We now move to our public comment. If we have any public comment in Las Vegas, please come forward. Make sure you state your name for the record and we will listen.
Hello, my name is Christopher Stokes, Stokes, Christopher common spelling. I'm a 40-year legacy operator, and actually this is in reference to the workshop that you held last week, which I really do commend you all at. I've been involved with marijuana since I was about 15 years old. I attended Rancho High School, not far down the block. I've had operations from Los Angeles to New York City and various ones in between. I actually had a record store, went under the guise Mecca Audio, but we actually sold to. I'm definitely one who has been negatively and positively affected by both the war on drugs and the legalization of cannabis. It's crushed the business for legacy, whether they tell you that or not. So what I wish to say without offense to anyone on the CC board is an old saying that I learned from my grandmother, that the road to hell is paved with good intentions. Unfortunately, the Nevada legislature has burdened the CCB with good intentions, yet there's been no real direction effectively leading to this little regulatory hellscape that we have going on here. I've watched for years between the previous board, taxation, and this board, and actually I commend this board for at least trying to get it right. But I see the frustrations and I see your efforts. So from the legacy side, what we have is no voice on any of the committees, boards, or panels. You ask us to come into workshops, and I'm going to give you my idea at a workshop that's going to be presented while I'm being removed from the conversation afterwards. So since the legalization of cannabis in Las Vegas, I relocated back here to avoid the stigma of purchasing and using marijuana. And although I'm originally from back east, I have always thought of Las Vegas as my home. And since I have been home, I've watched the CCB stumble forward in their attempts to regulate an almost unregulatable industry. The members here cannot see the forest for the trees, pun intended. I had to write this down, Chairman Douglas. With that said, I believe the solutions and insights are a way we can move forward and create a world-class industry, especially where cannabis lounges are concerned. Cannabis tourism can account for an additional 500,000 new visitors, benefiting in the creation of new businesses and tax revenue. This is the importance of cannabis to the local economy and to the state as a whole. I've watched as Nevada legalized marijuana and yet had no plan in place for folks to imbibe, effectively criminalizing a host of American and global visitors. Another example of good intent without direction. I've watched as dispensaries licensees went to friends and families under the initial board, and now there's the CCB. And I say kudos to you all. I see your efforts and energy, regardless of the massive amount of responsibility you have regulating a multi-billion, soon-to-be multi-billion-dollar industry. And we all know where there's money, there's corruption, born simply of greed or ignorance. And that's one of the committee members. And I kind of want to tell that for when I first came in, I was going to go for the social equity component of the license. Once I read through the social equity components, It's like, this is not it. It's definitely not it for me. That it was $1,000 initially, I could go for. But then when it was the 10,000 individual application, I researched the requirements to apply as the individual, and I balked once again. Trust me, I've done worse with more money, thrown it away. But for one reason, I couldn't see myself not even investing, but throwing away 10 grand. So I repeatedly heard that granting a consumption lounge license in Las Vegas was a golden ticket. But if we remember Willy Wonka, it was really a horror. So my advice to the figurative horror show that's going on now is to take a step back and reevaluate the position and goals of the CCB and ultimately the intent of the legislature. We are all dealing with an entire industry and not simply affecting small businesses. As a whole, we must evaluate the goals which the legislature believed were easy to assign, but currently hard to realign. In the legacy world, nor the current legal landscape, can we afford to hustle backwards. But that is what needs to be done to properly assess this industry's goals and positions. I ask that you include true legacy operators, sellers, growers, cultivators, and business peoples, not only in workshops, but in subcommittees and within the CCB board. I might need a few people with some nicknames. So I think that might. Oh, so I'll leave you with the awareness that as a legacy operator, if in my unoffered application for a cannabis consumption lounge, I addressed public safety issues, overconsumption, drug driving. I addressed all of those in my application, but then to put it forward to a lottery just seemed, it just didn't seem fair. Because we statistically know that lotteries are kind of a fool's game. I have a plan which includes law enforcement. Yeah, legacy guy. Yes, I have a plan that includes law enforcement, public safety, the CCB. Remember the conversation about how do we know that the cannabis that is bought here is brung in? Color coding. It's that simple. Spin a wheel, lands on yellow, like the whiz, all the product of the day is yellow. Law enforcement actually also knows that as well. We can work that out. There's details. But there are solutions from our side of the table that I guess really don't get this far because a lot of those questions would have been answered. I have a plan to dissuade overconsumption, to educate the public, consumers new and old. But I wasn't going to pay an unrefundable 10 grand to be passed over lottery style. So believe me when I say that legacy operators need to be included in these conversations and not just in workshops like last week or on the 14th. We need to be included on actual boards and committees, and it would behoove us all to alleviate the frustrations we currently possess. And with that, a strategic alliance, we can grow a world-class industry here at home. Thank you for your time. And I hope that I am able to speak to you in the immediate future.
Thank you, sir. Other public comment in Las Vegas? Seeing no other public comment in Las Vegas, any public comment in Northern Nevada?
Does not appear any public comment in Northern Nevada.
With no further public comment, that closes the public comment. We will go to the meeting minutes as our next item. If board members have reviewed that, if there's no corrections or changes, if we can get a motion.
Member Drat, I move to approve the meeting minutes from March 28, 2023.
We have a motion. Do we have a second?
Second.
Is
Been moved in second. Any discussion? Any corrections? Hearing none. All in favor, please say aye.
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 Any nays? Any abstentions? Matter carries. That moves us to our consent agenda complaint. We have one complaint on approval to proceed with disciplinary action. Respondent A.
Thank you, Chair. Item 3 on the agenda concerns one complaint for disciplinary action pursuant to NRS.
Name of the speaker?
Yes, thank you. Tyler Klimas for the record. Item 3 on the agenda concerns one complaint for disciplinary action pursuant to NRS 678A510. The Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. As we have done previously, I'm requesting board approval to proceed with this disciplinary action. And if approved, I will then authorize service of the complaint. Service will proceed within a reasonable time, and once it is out for service, it will be posted on the website. So as to respondent A, the complaint will allege violations of NCCR Regulation 4 and NCCR Regulation 10. That I'll turn it back to you, Chair.
We note for the record that this is on for request for consideration. As to the service of complaint, we note for the record that pursuant to NRS, the board has not seen that complaint at this time. We're just authorizing service and the fact that the Attorney General feels it's sufficient to move forward. Therefore, do we have a motion to proceed?
This is Member Young. I'll move that we approve the agenda item 3 to approve the proceedings for disciplinary action in regards to respondent A.
Thank you. We have a motion. Do we have a second?
Member Freilich.
Member
I'll second
Merritt,
it.
second.
We have a second from Member Merritt. We have a motion. We have a second. Any discussion?
Chairman, I just want to note that I'm going to be a no only because I expect us to go through with disciplinary action. I just think these complaints should wait until after this legislative session when we might have an entirely new process for disciplinary action. So that's the only reason I'm going to be a no.
Heard the reasoning for the no vote. I just note for the record that depending on what they do, regulations either go into effect upon passage or they go into effect, is it July 1? So this would really string things out for something that's occurred. We don't know the seriousness of this. Having said that, we've heard the discussion. All in favor of the complaint going forward, please say aye.
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 Nays?
Nay.
We have one nay. Any abstentions? Matter carries. Thank you. That moves us on to item number 4, request for consideration of approval of Charles Schultz Jr. as a receiver for NNV operations. 1, doing business as Silver State Trading. If we have parties, and if we can hear from our staff first, and we'll hear from the proponents.
Thank you, Chair, members of the board. Good morning. Emily Bordelove, Senior Deputy Attorney General, for the record for item 4. As noted before you today, for your consideration is a request to consider Charles A. Schultz Jr. as receiver for NNB operations due to incapacitation of the current receiver, Larry Birch. I will note at the outset that Mr. Birch did pass away last week. By way of background, on April 20th, 2022, Mr. Birch was appointed by a court as receiver over NNV, subject to final approval of the appointment and his agent card by the CCB. The chair issued conditional approval of Mr. Birch's agent card on April 27th and final approval at the board's May 2022 meeting. One of the factors favoring Mr. Birch's conditional approval was the fact that he'd already been vetted for the board as a receiver for another cannabis facility at an earlier February 2022 board meeting. The CCB also has a pending disciplinary action against NNB that was filed back in November 2021. That action is presently stayed pending settlement discussions and the issues with the receivership note. On April 12th, a joint petition to replace Mr. Birch with Mr. Schultz was filed by Mr. Birch's counsel and original petitioner's counsel with the court given Mr. Birch's medical condition. On April 17th, the court heard the petition and next day issued an order conditioned on this board's approval of Mr. Schultz approving the joint petition. That same day, as a hearing, Mr. Schultz's counsel submitted his application to the board, noting that he'd submitted his application for a cannabis establishment agent registration card for a cannabis receiver and his credentials pursuant to NRS 678B.355. Also on that same date, NNB's regulatory counsel requested that the board expedite consideration of Mr. Birch's application for this board meeting, given Mr. Birch's health condition, or excuse me, Mr. Schultz's application for this board meeting, given Mr. Birch's health condition, that NNB is currently operational, and the settlement discussion. Mr. Schultz is here with his counsel and also serves as counsel for Mr. Birch as his regulatory counsel for NNB for any questions the board may have.
Thank you. If we can hear from the proponents, and please state your name and tell us what you're going to tell us once we've had the parties introduced.
Candace Carlyon. I am the counsel for the receiver in the state court.
Jeff Barr and Alicia Ashcraft on behalf of NNB Operations.
Charles Schultz, president of Adamantine Services.
Justice Douglas and members of the board, I just wanted to take a minute to let you know why I personally recommended Mr. Schultz to complete the work that Mr. Birch had started. I have known Mr. Schultz for the last 10 years. We served together on the risk management board, which is a board that consists of, is a nonprofit that serves banks and other related industries here in Southern Nevada. I also worked with Mr. Schultz when he served as essentially the CRO of the Credit Management Association, which is a more than 100-year-old nonprofit that provides services to vendors who issue trade credit. And in that capacity, I not only worked closely with him in the successful restructuring of that 100-year-old organization, but CRA had also served as an assignee for benefit of creditors for dozens of liquidating companies, and encompassed in his role was effectively completing the liquidation of those dozens of companies. He has served as a CFO for a large bank. He has been investigated and bonded. He is very trustworthy. He is very competent. It's been a tough week. A week ago today, I lost not only a great colleague and client, but a treasured friend. And I personally recommended Mr. Schultz because I know that he can expeditiously and with our trust fulfill the goals that Mr. Birch had set out to obtain. Thank you.
Thank you.
Good morning, Justice Douglas, members of the board. Jeff Barr and Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of NNB Operations. This matter is, in a way, a great success. And what do I mean by that? I want to take the board back about a year and a half ago. The licensee NNB Operations was being run very, very badly. It owed many creditors, including most significantly the Department of Taxation. The rogue managers resigned, leaving the company in tremendous debt with absolutely no leadership and facing an existential disciplinary proceeding in front of this board. Now, Larry Birch stepped in as a receiver, and Larry managed to take control of the company's finances and make provisions for creditors. And most importantly, Larry was able to, number one, negotiate a proposed pending settlement agreement of the disciplinary matter before this board. And two, to find a prospective buyer for NNB Operations to make sure that the Department of Taxation has been made whole. In short, this is what a good receiver does. He takes control of the company and restructures it for the benefit of everyone involved. So that is why I say that this matter is a success in a way. The system worked in this case. Larry put together a team of professionals that included Richard Kleikamp from his office to oversee financial operations, Ms. Carline to advise the receiver on his legal obligations and help negotiate the proposed sale, licensee Ed Alexander to run the day-to-day operations, and Ms. Ashcraft to advise on licensing and regulatory matters. And I want to iterate, with this team, We are very close to putting forth a proposed settlement agreement for the board and selling the company to pay off the Department of Taxation. But simply, the CCB, the AG's office, and this team have worked collaboratively to take NNV operations, which was a rudderless disaster, and make it into a valuable going concern, which can be sold to pay off the Department of Taxation. Unfortunately, as you've heard, Larry Birch has died and cannot see this matter to completion. But again, because of the professionals on all sides of this matter, the system worked. And I want to personally thank Emily Bordelove and Chris Rath for their tremendous assistance in helping us through this difficult time. This team jumped into action, and we've proposed a new receiver, Chuck Schultz, at the recommendation of Ms. Carline, to fill the enormous shoes of Larry Birch. The court has already approved Mr. Schultz as a receiver, of course, subject to this board's approval. Mr. Schultz has applied to the board, and Mr. Schultz is committed to keeping the team in place to finalize the great work Mr. Birch has done. Now, I want to take a look at NRS 678B.355 for a minute. That statute sets out the qualifications of a receiver in the cannabis industry. This first begs the question of why would the legislature insist on providing for receivers over cannabis companies in the first instance? And the answer, of course, is that cannabis companies are legally prohibited from filing federal bankruptcy. And if I'm being a bit pedantic here, I apologize, but I really want to stress the receivership statutes are in lieu of federal bankruptcy proceedings. I want to specifically address some language in the statute, specifically subsection 2E. This provision begins, quote, proof satisfactory to the board that the applicant has, and then it lists some qualifications that the board can consider. Now, why would the legislature start with the words proof satisfactory to the board? Well, the answer is it wanted to vest in the board some amount of discretion, some measure of discretion. The statute doesn't say what proof must be, what that proof must be. Instead, it says that whatever proof is provided must be satisfactory to the board. This makes eminent sense if the receivership statutes are the substitute for bankruptcy proceedings. Bankruptcy judges exercise broad discretion, and it seems that the legislature intended this board to exercise similar discretion in similar type proceedings. Now let's take a look at the specific qualifications. Specifically, I want to look at 2E2, where it says, quote, experience as a receiver by the court. Now, as a preliminary matter last week, district court just appointed Mr. Schultz as NNV operations receiver on an order shortening time. It did not hesitate to appoint Mr. Schultz as a receiver. But I confess, when I first looked at Mr. Schultz's resume, I didn't see the word receiver. Didn't see it anywhere on there. Now, I saw that Mr. Schultz has been appointed as chief restructuring officer by the bankruptcy courts on scores of occasions. That is my ignorance of bankruptcy law. Ms. Carline had to gently explain to me and diplomatically that a chief restructuring officer or a CRO is the functional equivalent of a receiver in bankruptcy. So, for example, both are independent third parties appointed to oversee the financial affairs of distressed companies. Receiver in the state court, CRO in the bankruptcy. Both have the power to sell, to buy, to negotiate the hire, and to make final recommendations to their respective courts. Again, a receiver in a state court, a CRO in the bankruptcy court. Both have legal reporting requirements to their respective courts. Both are subject to high levels of scrutiny and held to high standards of accountability. Both are expected to have a deep level of understanding of financial restructuring. And finally, both are expected to balance and protect the interests of all stakeholders. With his decades of experience, Mr. Schultz has more experience in the role of receiver than even most nominal, quote unquote, receivers. His vast experience uniquely positions him to finalize the instant matter, and thus this portion of the statute is satisfied. I want to address one other provision of the statute, and that's subsection 1, experience in or knowledge of the cannabis industry. And again, I will speak candidly here. Mr. Schultz has no direct cannabis industry experience because this is a nascent industry. Few people do have that direct experience. But Mr. Schultz has assembled the very team that Larry Birch has assembled. Richard Kleikamp will still be overseeing the financial operations. Ms. Carline will continue to act as receiver's counsel. Ed Alexander will continue to operate the day-to-day cannabis operations of NNV operations. Ms. Ashcraft will continue as licensing and regulatory counsel. This team of Chuck Schultz has enormous experience in or of the cannabis industry. And when Larry Birch fell gravely ill, it was this team that leapt into action, developed a plan, and has brought this matter before you in the span of about 10 days. I have spoken at length here, and I am sure the board may have questions for Mr. Schultz, Ms. Carline, or Ms. Ashcraft, or me, but I want to conclude with this observation. The system worked in this case, and it continues to work well under these incredibly unique circumstances. Without Mr. Schultz's appointment today, NNV will be right back where it was a year and a half ago. It will be a rudderless disaster with no ability to repay the Department of Taxation, with no management to approve a settlement with the CCB, and potentially with no buyer. We are this close to finishing this matter to a wildly successful conclusion. I urge the board to approve Charles Schultz as the receiver of NNV operations to complete the job started by Larry Birch under the aegis of both the court and the CCB. Mr. Schultz and the team are here to answer any questions, and I thank you for your time.
Thank you. And Mr. Schultz, you wish to address the board at all?
Other than Charles A. Schultz Jr., I thank you very much for the opportunity of being here today and pleading our case to try and get this to fruition. But I've been in the turnaround industry officially for 20 years. I've been working with challenged companies for over 25 years. I've had somewhere in the neighborhood of 50 different cases I've worked on during that time. As far as cannabis, there was a point in time where I said I didn't believe there was any industry I hadn't worked in. This will be the first time in the cannabis industry. However, I have worked in the retail industry. I've worked in production, manufacturing, which are the two applications I've applied for. I believe I've seen most everything that can be thrown at me, and we have a terrific team here to try and finish this process. Are there any questions I can answer from you?
Questions from board members at this point?
Mr. Chairman, this is member Ms. Monfrey. Like, I have a question. I just wondered what the status is on that the purchase and sale agreement that was signed, perhaps but not finalized.
I believe that yesterday, what I hope is a final draft was circulated to the parties. Once Mr. Schultz is hopefully approved by this board, he will be in a position to make any final modifications to that nearly final document, sign it, bring it before both the state court and this board for approval. This is Candace Carline, sorry.
And Jeff Barr, I will also add that the purchase and sale agreement is conditioned upon successful resolution of the disciplinary matter before the board.
I have a question that would probably be for Jeff or Alicia. What happened to the Suttons? This is really sad to see because I know they got into the business because their son needed pain management, and they put in a lot of their own personal savings. Where are they now? And
yeah, so Jeff Barr, Member Durrett, thank you for the question. We haven't had any contact with the Suttons since they resigned. I know that the executive director in the AG's office have been very, very concerned that they would have any kind of management or operational. They have none. We've not been in contact with them. They basically wiped their hands of this matter and walked away. I suspect that there's some other issues out there that I'm not privy to, but as far as their involvement here, they've had no involvement for a year and a half, and they won't have any involvement going forward. Equity here is getting wiped out if this deal goes through as it's supposed to go through.
and the only other thing I would add is I think if this is approved today, there should be a condition or requirement that if the team falls apart for some reason, which is I know not likely, that the that the receiver would need to come back to the, and let this, have a new discussion.
Thank you, Member Director Jeff Barr. We don't have any problem with that condition. We agree that the team is integral to this, to the success of this. It's been integral to the success of this matter, and we would agree with those conditions.
For the record, Chair Douglas, we note that this is kind of unique. Mr. Schultz is someone who's been appointed subject to our approval by the district court. However, he has not had prior receiver experience. It's been noted that he's had experience that is equivalent of a receiver. And additionally, he does not have a cannabis background, but he has transferable skills that his resume indicates in managing the restructuring of businesses and putting them back together, in essence, when they're been, I'll just use the word, trashed. And most importantly, the area of concern that the board has is experience in the cannabis industry. And as mentioned, it's kind of an interesting question, but we note that that team has been assembled. It's still in place, that has experience in the cannabis industry, running the day-to-day operations, legal compliance, and so on. So keeping that team in place is very important, as Member Durrett has indicated for the record. There is the obligation to make monthly reports to the board as to what is going on. So, and the only concern I have is if Mr. Schultz has begun to at least familiarize himself generally with the rules and laws related to cannabis industry.
This is Charles Schultz. Yes, Chair. I'm willing to do that.
Other questions, board members?
I would just point out that you have no idea what it's like to operate without banking until you do it. And so you're going to be in for a lot of rude awakening. So, but the team sounds great. So.
Well, unless we've been misled, it sounds like they're very close to resolving outstanding challenges.
Yeah.
Ramiro, did you have something? No. Okay. That being the case, if the board has no further questions, if we can get a motion. However, that's going to be. Member Durrett, did you have some thoughts on the motion?
Member Durrett, I move to approve the appointment of Mr. Charles A. Schultz as the receiver for NNB operations, pursuant to, of course, our requirements on receiverships, with the additional condition that if there is a significant or material change in the team that you're currently working with, that you will proactively bring that to the board's attention.
We have a motion. Do we have a second?
Jerry Merritt, for the record, I second.
Any additional discussion? I have one minor question. Mr. Schultz has made application with the board.
You made an application
Chairman,
for an AG.
I'm sorry, can you get closer to your mic and repeat what you just said? Thank you.
My question was whether or not Mr. Schultz has made application to the board.
Jeff Barr, for the record, yes, he has applied for both an agent card and for the receivership.
I know we've been
Receiver.
moving fairly fast with what's
We
going on.
appreciate that.
We have a motion. We have a second. Any other discussion? All in favor, please say aye.
Aye. Aye.
Aye.
Any nays? Any abstentions? Motion carries. Mr. Schultz, welcome to cannabis.
Thank you.
And good luck to you.
Thank you.
Item 5, I don't know if Helping Hands is. We did make it. Okay. I'm glad you were able to move around the traffic cones and everything else that's out there these days and get here. This is item number 5, consideration for final approval of conditional lifting of summary suspension, Helping Hands Wellness Center, Inc. report from our staff, please.
Thank you, Chair, members of the board. Emily Bordelov, Senior Deputy Attorney General for item 5 on the agenda. As noted before you today is consideration for the final or issuing final approval, the conditional lifting of the summary suspension for Helping Hands. By way of background, January 5th, 2023, board agents conducted a follow-up inspection at Helping Hands facility where its cultivation and production licenses are co-located. During the course of their investigation, board agents discovered, in part, cannabis and cannabis products in multiple forms stored in a storage closet and cannabis clones in the attic. Neither of these areas are approved for cannabis storage, and neither had surveillance video coverage. Also, there was incomplete surveillance video coverage, and there were surveillance videos produced showing 2 different employees concealing cannabis. Employee can be heard discussing a plan to conceal cannabis, and an employee discussing his plan to return to the facility after board agents had left to remove cannabis from the facility. Also, there were additional concerns regarding the facility's keycard access system. On January 24th, 2023, the board held an emergency meeting and voted to summarily suspend Helping Hands, finding it posed an immediate threat to public's health, safety, and welfare. Helping Hands submitted plans of correction, and on February 23rd, 2023, the amended 4th plan of correction addressed concerns with security, employee training on handling cannabis, and concerns regarding the certain employees viewed on the surveillance videos access to cannabis. On February 24th, 2023, CCB approved this amended 4th plan of correction. And on February 27th, Helping Hands confirmed that all training identified in the plans of correction were completed or would be completed for new employees, and addressed the certain employees' access to cannabis. Given the above, the CCB confirmed that Helping Hands corrected the deficiencies outlined in the order of summary suspension, and thus conditionally lifted the summary suspension for final approval of the lifting to be presented to the board at its meeting. Helping Hands was permitted to resume operations after its 34-day suspension. A representative from Helping Hands and its counsel, Jared Kahn, are both present for any questioning from the board.
Morning, Chairman Douglas, members of Executive Director Klimas. My name is Jared Kahn. I represent Helping Hands Wellness Center. With me today is Clarice Tertarian. She's the principal owner, and also her husband, Alfred Tertarian, who also supports the operation. I do want to thank staff and Ms. Ponkite, everybody for working with us to get this summary
Excuse me,
suspension
sir,
lifted.
can you speak closer to the microphone?
Happy to do so. Sorry about that. I do want to thank staff and everybody involved and the investigators for helping lift the summary suspension. Unfortunately, this was kind of one of those terrible incidents. We had one of these before, a different entity last year, where employees kind of went rogue. Mr. Tertarian, who usually runs the facility on a day-to-day, was absent due to illness, and he was in California and was unable to be there. And then these employees basically decided to allegedly conduct these affairs without them knowing. Those employees are now no longer with the facility, and the facility is back up and running and getting back to business and will be compliant going forward. It's just, again, an unfortunate circumstance when employees kind of take advantage of a situation, you know, when the when the boss isn't there in this industry. So, and they've paid the price, unfortunately, significantly, as you can imagine, by being shut down for that and having to deal with all this. But, at this point, we're here to address any questions or concerns. Just appreciate again staff and everybody working with us to get this summary suspension lifted, and looking forward to getting back to business.
Chair Douglas, for the record, reviewed your plan of operation, noting, as you indicated, the 2 employees primarily at issue, besides some other issues, been terminated. Training has been reinstituted and whatnot. The critical thing for any licensee, unfortunately, is that they're only as good as their staff is, and the supervision of his supervisors or her supervisors is critically important.
Yeah.
So they don't go, as you said, rogue.
Right.
But
no, and the licensees understand that you know they're still responsible. This is their business and responsible. And if you know if an employee does this, that still falls on them, right? And that's what. So.
Other questions by board members or comments?
Mr. Chair, I just have a point of clarification. Mr. Zachary, is he still employed, or will he be terminated, or has he been terminated?
He's been terminated, will no longer be employed by the entity.
Thank you.
It's noted in the plan of correction, Amy Gazelle and Zachary Gover, I guess, Varia, that have been terminated. One had been a manager and the other was an employee. So with that, if there's no further questions, board members have any additional questions or ready for some motion?
I'd be happy to make the motion. Member Drat, I move to approve the conditional lifting, I move for final approval of the lifting of the summary suspension of Helping Hands Wellness Center under agenda item 5A.
We have a motion for the lifting of the summary suspension. Do we have a second?
It's Member
Member
Young, I'll
Merritt, for
second
the
that.
record, I second.
We have dueling seconds, Member Merritt, Member Young. Note for the record that with this motion, it does not eliminate any possible disciplinary action that may occur. But having said that, all in favor of the conditional lifting of the suspension, please say aye.
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 Aye. Any nays? Any abstentions? Matter carries. Good luck, sir and ma'am, and may the gods be with you.
Thank you. Thank you, everybody.
We are now to item 6, request for transfers of interest. Greenway Medical LLC, TOI 21040, C018, RC18, and T040 for possible action.
Chair Douglas, Member Merritt, Member Durrett, Member Young, and Member Bismuth-Fraley. For the record, I am David Staley, Division Chief of Investigations for the CC. I'm here to present agenda item 6, which consists of 3 transfer of interest or TOI applications. Item A is a TOI application to Greenway Medical LLC, cultivation distribution company in Clark County, Nevada. TOI number 21040 requests approval for 4 existing members of Greenway Medical to purchase the entire 9.5% membership by Christopher Fresquez.
Excuse me, I'm sorry to interrupt, Mr. Staley. Can you just go back a little bit to that last number, 2140? You're cutting out. I don't know if you're turning away from your microphone.
Yes, ma'am, I'll try again. TOI number 21040 requests approval for 4 existing members of Greenway Medical to purchase the entire 9.5% membership by Christopher Fresquez. Fresquez is selling its membership to exit the cannabis industry. Greenway Medical has also requested waivers of NCCR 5110 pursuant to NCCR 5.112 and 5.125. If approved, requirements for prior board approval of transfers of less than 5% of Greenway Medical's ownership and agent card requirements for owners of less than 5% will be waived. Greenway Medical has adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Greenway Medical's 5.112 and 5.125 waivers to expire on its next TOI agenda date. No areas of concern were identified during the investigation into this TOI application. I am available for any questions, and my understanding is that Amanda Conder and Dustin Vina are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. From council and licensee.
Good morning, Chairman, members of the board. Amanda Connor, on behalf of Greenway Medical, and with me is one of the owners, Dustin Venna. We kindly request approval of this transfer and the waivers, and are here to address any questions. Thank you.
Sir, if you'd state your name and identify who you are, please.
Dustin Vina, I'm one of the owners of Greenway Medical.
Thank you. Questions by the board? And noting for the record that staff's review indicates no areas of concern. If we have no questions,
Member Dret, I move to approve the requested transfer of interest under agenda item 6A relating to Greenway Medical. In addition, the requested waiver of 5.110 pursuant to 5.112 and 5.125 would be granted. Those waivers would be set to expire on the next time a TOI was agendized. The next time a TOI was on the agenda for the subject company.
we have a motion with the conditions. Do we have a second?
Member Young, I'll second that.
Been moved and seconded. Any additional discussion? Hearing none. All in favor, please say aye.
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 Aye. Any opposed? None. Any abstentions? None. Thank you.
Thank you, and thank you to Investigator Dean and Chief Investigator Staley for their assistance on this.
That moves us to item number B, Polaris Wellness Center LLC. TOIs 22012, as well as C168, RC168, P114, RP114, TO68, and RD636 for possible action.
Chair Douglas, members of the board, for the record, this is David Staley. Item B is a TOI application by Polaris Wellness Center LLC, a vertically integrated cannabis company in Clark and Esmeralda counties. TOI number 22012 was filed requesting approval for the return of membership interest back to Polaris due to a settlement agreement with two existing members, Robert Johnson and Frederick Nielsen, and a redistribution of membership to existing members. Polaris has also requested waivers of NCCR 5.0 pursuant to NCCR 5.112 and 5.125. If approved, the requirements for prior board approval transfers of less than 5% of Polaris's ownership and agent requirements for of less than 5% will be waived. Polaris has adequately addressed the items required in NCCRs 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit Polaris's 5.112 and 5.125 waivers to expire on its next TOI agenda date. Staff have identified an area of concern regarding this TOI because Johnson and Nielsen's membership interests were returned back to the company on March 31st, 2022, 2 months before Polaris filed its TOI application. After a dispute and related lawsuit, Polaris, Johnson, and Nielsen entered into a settlement agreement providing for Johnson and Nielsen to abandon their shares in Polaris. In a March 14th, 2022 letter explanation to Director Klimas, the company explained that the abandoned membership would convert directly to Treasury membership interest on March 31st of 2022 and held in reserve by the company. Additionally, the settlement agreement provided for Nielsen to be paid over $1.5 million and Johnson to be paid $1 million. Abandonment generally means the voluntary relinquishment of ownership of property, but does not typically include being compensated for such abandonment. Compensation is generally associated with the sale or purchase of property, leading staff to question if the transfer was a true abandonment or simply a term used in the settlement agreement to qualify the transfer. Despite the lack of clarity surrounding the abandonment of the membership interest, the company clearly explained membership interest went back to the company as Treasury membership interest on March 31st, 2022, which is an unapproved TOI. In addition, the company's shareholders' equity, which includes membership interest, increased commensurate with the return of Nielsen Johnson's membership interest, further identifying the transfer as an improved TY. In its March 14th, 2022 letter, the company explained the transfer process here is not applicable as there is no personal transferee. However, a transfer did occur between Nielsen, Johnson, and the company. In NCCR 1.37, relevant part provides that person means natural persons, applicant, limited partnerships, limited liabilities companies, corporations, publicly traded corporations, private investment companies, trusts, holding companies, or other form of business organization such as defined by the board. I am available for any questions, and my understanding is that Tisha Black, Lee McHugh, James Switzer, and Frederick Nielsen are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you.
Good morning, Chair Douglas and members of the board. My name is Tisha Black. I'm from the law firm of Black and Bottoms. And with me, I have my colleague, Paul Larson, and also Lee McHugh, who is a principal of Polaris Wellness Center. So I would like to, I'm going to start this because it's a very complicated situation. And over the last 15 months, it's been nothing but a battle with staff. This matter arose in, let me take you back a bit. There were five members of Polaris, each having 20% ownership, totaling 100%. In September, in 2020 and 2021, the five partners began to fight. Two partners sued the remaining three partners, Lee and Peter and Jim Switzer. Frederick and Robert sued the other three, and they also sued the company for claims of improperly running the company and all measure of claims that parties claim when they are fighting over a business, a small-owned business. So realizing that litigation was very expensive and it was a he said, she said, and a very conflated set of facts, in September, the parties agreed to a tolling agreement because it was the cost of the litigation was taking too much toll on the business. So they agreed that instead of continuing to fight, they would see what they would do to work together. So the tolling agreement expired in September of 21. And in September of 21, the five parties commenced to work to restructure a bunch of debt with outside lenders to get some processes and procedures in place. They did that fairly well, but every board meeting, which I was presiding over, was very heated and contentious, and there was always threats. Fast forward in February of 22, having just restructured the debt, got all of the lenders on similar notes. One of the members, Robert, stated that he had a child custody battle, and his child lives in another jurisdiction, and the mother was making claims that he was an illegal drug owner and or illegal drug dealer, and the court in that jurisdiction, which I believe is Minneapolis, Robert felt that it was really imperative for him to quit his membership. In addition to Robert deciding that he was going to quit his membership, and he just told me, I am done at the end of the month, right? I am done March 31st. So the parties still had allegations and they were still contentious with each other under the litigation, although the litigation had been dismissed, but not with prejudice. When Robert indicated that he was going to quit and didn't care, he did not care, the TOI process, anything like that, he was done. He wasn't looking for any remuneration, but he did say he was going to resurrect, or there was threats that he might resurrect the lawsuit. With that, Robert and Frederick, who came into this venture together, Robert said that he wanted out, or Frederick said that he wanted out as well because he is from Sweden and he was living back in Sweden, didn't want to have the problems if his other partner was going to leave, and he quit. They both told me they were going to be done March 31st. So regulations are a lovely thing, right? If they fit your fact pattern. This didn't fit my fact, none of the regulations under 5110 or 648B or Chapter 52. None of them fit my fact pattern. So what do you do when your regulations don't fit? You call the regulators. So March 3rd, I was proactive, as I should be, as I always have been. My clients have nothing to hide. They're great business owners. They've worked very hard to keep this business in shape and afloat amongst 3 years of very contentious litigation. Because as we all know in cannabis, many of these partnerships were forced partnerships. So they don't always get along. And in a bureaucratic world, with no disrespect, you make regulations that you think work. But in the real world, sometimes they don't. So I called staff. I called also at the time one of the governor's senior staff, Sisolak's senior staff, to ask what we should do, because specifically I knew the TOI process would take too long and they were both gonna leave. And I don't have control over these two individuals. No matter what anybody thinks, people can decide to stop and quit and leave. And membership in an LLC, as is stock in a corporation, is a property right. And I have no control over how they value their property. If they deem it to be worthless or they deem it to be millions, I have no idea. But I can tell you, they deemed that the causes of action under the lawsuit, which were related to basically the value of the business, because they were saying it was improperly run, the two departing members deemed that their causes of action under the lawsuit had much more weight and monetary value than their membership did in Polaris. So back to May 3rd. Back to March 3rd. Between March 3rd and March 17th or 14th, I believe, my first letter, I contacted the CCB 4 times. I contacted the senior staff, Daniel Stewart, who I believe spoke to you, Mr. Klimas, about this particular issue because it's novel. I was told that my clients would fall nicely into a new program of shortened transfer of interest. But still 30 days was not going to be plausible. I couldn't talk the other two people into staying. I'm not going to argue with his man over his child. That's his decision. I couldn't tell you whether those facts are true or not, but nonetheless, he decided to vacate. They both decided to abandon their property interest, and they did so on the 31st, exactly as I said they would. I informed the board the whole time, by phone, by letter, everything available to me, I did. So since Robert was leaving and Frederick wanted to go with him, they both vacated. They both decided that if they wanted to, they could resume their causes of action under the lawsuit and be remunerated for damages for poor operation was the claim. So I thought, being proactive, I thought that I actually had an elegant solution for all parties involved. I called the board. I called the board, told them about this vacation. I spoke to Robert and Frederick, got the lawsuits settled, and filed my TOI application. So as I said before, this has been a battle from the very beginning because I have a fact pattern that doesn't fit any regs. And though it is a fine difference, it is a difference at law and for taxes and many other reasons, whether you vacate a membership interest or you sell a membership interest. And in this case, there was no membership interest that was sold, irrespective of how staff continues to want to think of it. There was a settlement of the lawsuit, and although they were done on the same day, because that's the way as a lawyer you're supposed to do things, is button up all loose ends when you can. I got rid of the lawsuits in its entirety. They vacated their membership, which left the company free of any threat of claim or inactivity or activity that is bad on behalf of these other two partnerships or on behalf of these other two partners. And then we move forward. So as we stand here today, let me bring up the second claim. The first is the consideration, which is an item of concern of Mr. Staley. And that is because he believes, irrespective of how many times I've gone back and forth with him, that the consideration was somehow some clandestine or related consideration. It was the settlement of the lawsuit. It says that in the resolution. There was money paid because of the settlement of the lawsuit for both parties. One was done in cash, because the company had cash, and the company is the one that paid because the company was named a defendant and still could have been a defendant if the lawsuit was filed again. The members didn't pay. The members don't have any, there's no change in membership for them. They each have 20% of membership still. The second claim is that, the second claim is that it took 6 weeks. Well, it took 6 weeks once again, because I'm trying to deal with a round hole and a square peg, right? The transfer of interest form says that you have to have all transferors sign the interest form. First of all, it's not a transferor. Second of all, they vacated, they left, they have nothing, they want nothing to do with it. I tried for weeks to get them back on board, at least to sign those documents, and they would not. So, yes, it is an unusual circumstances, but on no level was I not proactive, was I not transparent, was I not open? On occasion, I was not cooperative, and I will say this is because they staff sent me an agreement for this fast track program, the conditional program, which we were originally involved in. And I was supposed to be on the schedule for October, or Polaris was supposed to be on a schedule for October for this transfer. And the agreement they sent me, now mind you, by the time October came around, Robert and Frederick had been long gone, right? Robert had already testified in court that he was not an owner, owned no membership whatsoever. So this agreement talked about transfer, not vacation, not abandonment. By this time, both parties had already seen their tax advisors as well, and there is a great difference, as I said before, between abandonment and sale of a property interest. Abandonment has different tax consequences than a sale has. So by the time this agreement came around, there was transfer all over it, there was typos all over it, and it was forcing my client to make statements that weren't true. And it was also forcing them to waive all rights. There's a waiver clause in that agreement that waives all rights, whether known, unknown, what have you. And these are 5 contentious parties. I don't know what might come about in this next, in the final conditional review, because I thought the short form transfer was done. I thought it was buttoned up once I came in October, but then I learned that there was still an investigation that would ensue. There was still more months for this to finalize. I did not know, and I could not have my clients waive any rights if the other 2 were going to be affected, because it would start the litigation again. So we did not participate. We withdrew from the conditional program, and here we stand today. There's 40% membership that reverted back to the company. There's 20% held by Mr. McHugh, 20% held by and 20% each held by the other 2 partners. There was no consideration paid for it. And the reason it took 6 weeks is because my fact pattern does not fit the regs. And despite trying very hard, this is all the correspondence and all the documents that I have sent to staff. I've produced financials 3 times. I have produced tax returns 3 times. I have drafted letters nearly ad nauseum, very long, explaining the whole story. And while I appreciate that a lot of people involved in the CCB and maybe even some members of the board, and I say this with all respect, haven't practiced transactional law for 25 years as I have, and there are distinctions, but these distinctions make a huge difference. Abandonment and transfer, that language is huge, as is, it has very significant tax and legal consequences. And further, as I read the statute under 5110 and section 52, neither of those relate to my specific fact pattern. They say an other marijuana establishment or a person. This didn't go back to a person, and it hasn't gone back to another marijuana establishment. The fact is, the people that have the members that have the membership are 3 members that have already been vetted, and their membership did not change. What has accreted to the new membership is the company, and it's not a person. Nonetheless, I called, we've submitted everything, and I am dumbfounded at how difficult this has been, because it's just things in the real world don't happen nicely always as they are meant to be under the regulations. And while I'm not trying to be disrespectful, and I appreciate the hard work that Mrs. Prince and Mr. Staley have done, it has been a very difficult and costly, this will be a very, very costly process that my clients who already have a business that is dealing with market pressures and past litigation and settling with lenders is now going to have to pay a large bill so that we could educate staff, hopefully, on the difference between a vacation and a sale of a property interest. That being said, I do think this is something that the board should look at very carefully, because I would hate for this to be used in a nefarious way for other license holders or other members or shareholders of other companies. But this is not surreptitious. There is nothing there is nothing about this that actually staff and the board should not be proud of, because we were proactive and we're trying to catch all the loopholes. We found a gap. We only want to close it. We don't want to argue about it. We don't need to spend extra money on T&E bills that I know are going to be through the roof. These people have to get to work. Anyway, so I thank you for your time. That was a very long explanation. And I just ask that the board notice the present structure of Polaris and approve it. And I'm pleasure to answer any question.
Any other representations? Chair Douglas, for the record, from my standpoint, I've listened to the narrative. I appreciate council's narrative, offering mitigation as to what's gone on, transactional. But from my standpoint, this is a regulated industry. And when you start moving things around in ownership, it tends to be a transfer, a regulated industry. Having said that, I don't have a problem with the transfer. I do have a problem as to what we do with the real life situation that occurred. And I'm willing to approve the TOI subject to this referred back to staff to look at that to see whether or not what should be done, whether we should look at your mitigation, grant it, whether the parties can resolve it, or whether it needs to go further to a full disciplinary. But that's just my position. Other board members, based on their review of all the facts and what they feel about this particular issue, I'd like to hear their input.
I have a couple questions. Remind me again of the timeline, because it's all spelled out multiple times, but the 6 weeks that were pending until an application was filed, you had already been in discussion before then with the CCB and the governor's staff. So this was not like a surprise when you filed the application.
No, not at all, Member Durrett, and thank you for the question. This is Tisha Black. So I have a timeline that I prepared for myself, which I'm happy to give the board. But essentially, and why it's not there, I don't know. I spoke to the board, I spoke to staff, I spoke to Daniel Stewart 5 times. I spoke to Mr. Staley himself several times. That was before the 14th when I sent a letter that was super comprehensive, right, of exactly what I was going to do. And at that point in time, I never was told no. I never was said you can't do that. Everybody said, oh, you know what, you will fall greatly into this short form program. That's all the feedback I received. Yeah, this is a 7-page timeline of everything I've done in terms of informing staff, working on this issue with the CCB. So no, there is no way on any stretch, even in between the 6-week timeline of filing the application, I was in contact with them as well because I couldn't find the 2 vacating members, right? And because also we had some issues with taxes, so it took us a minute to get our tax, our tax letter back. So ultimately, on May 20th, the members that remained signed the attestations or the affidavits that needed to be signed because we gave up on the other 2. And nobody made mention about the fact that we had, gave up on the other 2. Now the narrative is, oh, we were 6 weeks late and we weren't trying.
Um, I have a couple, okay, I want to go over this real quick, but first, it would be so hard to believe that somebody would walk away from their interests and so that the settlement funding wasn't to make up for them walking away from their interests, but I've seen it happen. I've seen people say, I want out and say goodbye to their money for no, and so, okay. It's probably, if I hadn't seen that personally, I would
Well,
I would
I
probably.
think especially when the one fellow, lives in a separate country and his partner, but do you know what I'm saying? His business partner is out, and the two of them have been fighting with the other three of them for years, right? I can see why he wouldn't want to stay. And Robert, the original partner, or the original member, excuse me, that stated he was going to leave, he has a child custody issue. I mean, what do you do about that? And that's a real issue in cannabis. It's a very real issue in cannabis, right? And I'm sure when Robert got in the business, I don't even think he had the child at that point in time, but then he has a child, he's in a business, they're in a jurisdiction that doesn't have cannabis, and now he's fighting with the other members. He deems it to be worthless, and he's going to lose his child over this or have a negative inference and in a custody hearing. It happens.
Okay, so the relevant, I guess questions might be for Dave. Okay, the relevant portions just in general are a transfer of owner under 5.1101, a transfer of ownership interest in any amount is not effective until the board has been notified on a form prescribed by the board. And then under section 4, a person shall not sell, purchase, assign, lease, grant, or foreclose a security interest or otherwise transfer, convey, or acquire in any manner whatsoever any interest. So I think it's clear that they were juggling with this abandonment and trying to find the best way that they could juggle with it. What could they have done other than put it in their treasury stock? It's kind of like an escrow. If people are walking away, how can they have any control over that? And I don't want to say, well, we don't have a process for that, because our regs are going to have to be flexible. We don't want to have every single thing spelled out. So I just kind of want to have a discussion on that. No, yeah.
David Staley for the record. In early March, Ms. Black and I did discuss these transactions several times. We discussed the idea of placing the share amounts in escrow account or a restricted account, which has been used in the past. We also talked about the potential for the conditional process, which is an expedited process. The conditional process didn't meet their needs because of the facts of the case. The area of concern that we have in very simple terms is that the shares transferred in any manner, as you mentioned, out of the regulation, they transferred from the owners to the company. That's not a TOI. That's our very simple position. And we did talk about potential options during our conversations.
What's the difference between putting it in their treasury stock and if they're putting it there and they're not putting it up for sale at that and an escrow account?
And
what would the escrow account look like? Like, would that be with a title company?
Well, yeah, we've used that in the past with other licensees that have had cases where I think one member was found guilty of a felony and was going to prison. That TOI is pending, but the shares were put in a restricted or escrow account where nobody had control over them, either the company or the individual spouse. And that was a method, while not perfect, it was a method to address or limit that, I guess, to provide that the shares didn't transfer back to the company or back to other shareholders.
If I may, we did discuss the idea of an escrow. Since these membership shares have they're back to the company, nobody's claimed them. They have not been sold. We don't have certificates. They never issued certificates, and it's an LLC going to convert into a C corp, but they don't have certificates to escrow. Nobody owned anything. So under 82, because of the financial situation of the company, under NRS 82 or 86, which governs LLCs, You couldn't do a distribution of any equity if the company would not otherwise be able to pay its bills normally. That's also under the operating agreement. With regard to transferring shares, the operating agreement doesn't allow you to transfer shares unless you have all 5 members that agree. And we haven't been able to amend our operating agreement because we're waiting for this. So it's an impracticality to escrow certificates that don't exist, right? And we felt, as I discussed with Chief Staley, is that we are restricted from the operating agreement itself, which has not been amended because we haven't finished this process. We are restricted by the statutes to sell or transfer or distribute any money otherwise. So other than going through the process of just creating a certificate to have a certificate that was never distributed, and them spending their time on me and then naturally their money on me for something that it's form over substance, right? It's 6 or a half dozen. The fact of the matter is nothing has been sold, nothing has been distributed, and we're waiting for this process to conclude. But I still don't know what the answer to the question, if Lord forbid I should ever have this issue again with one of my clients where a member comes up and says, I'm out. I do not care what you say. How do I react to that? And it happens because in other jurisdictions, cannabis is not legal and people suffer impunity or a bias because of being involved in a cannabis company. I'm not saying it happens often. I'm not saying people vacate their property ownership often. I'm just saying it happened in this circumstance, and I was proactive. But I don't fit, this fact pattern does not fit in the regs, and it does not fit in the process of the CCB. And now, as I understand it from Mrs. Staley, my client or myself stand to be penalized because we were proactive.
Ms. Black, I appreciate your work on this. I appreciate trying to find a solution. I note for the record, though, in this, and you've hit it and we've glanced over it, it was very important to one of your clients to be able to testify on the record that they had no interest in cannabis because of the child. Real world problem.
Yes, sir.
So, and that is kind of a sticking point to me. So I have no interest. So their interest is gone.
Yes, sir.
It wasn't an escrow. It wasn't anything else. That's a fact we have to live with. And as I said, I think the TOI should go forward. I don't have a problem with it. The question is going through and looking at the fine lines of what happened, whether in our eyes it is in fact a violation, whether in fact, based upon what you're providing to us, there's sufficient mitigation to either have no penalty or very minor, if any, or the party says, no, I don't want any penalty. I'm going to take this because the area is uncertain. I think that at the end of the day is kind of where we're at right now, but that's my feeling.
I appreciate your opinion. Thank you.
So, but
Mr.
I
Chairman.
understand council's burden trying to find a solution.
Yeah, like I am the focal point of much ire, which I guess is why we're attorneys, right? So I'm sorry, I think there was a question up north.
I do. This is member Guzman Frelick. I just want to make sure that I understand exactly what's happened because this is very complex, but I just want to make sure that I understand it fully. So it's my understanding that based on a settlement agreement between the owners, 2 of the members have relinquished any right to the the property rights of the company because they're going to walk away, and nothing has transferred as of, other than that settlement agreement, nothing has transferred or has monies exchanged. Because I know we talked about putting something in escrow, but is there anything to put in escrow? And there was no paper basically to put in escrow. So I guess the bottom line is my question is, have any assets transferred as we sit here today?
There has been no assets that have transferred as we sit here today in relation to the abandonment of the membership shares.
Thank you.
And thank you.
And maybe, Ms. Black,
This-
your letter of March 14th of 22 indicated that the abandoned shares would be voluntarily relinquished back to the company effective as of March 31st of 2022.
Mhm.
I would read that to mean that there was a transfer of that membership interest from the individuals to the company. Is that what occurred?
It
That was an abandonment.
it was an abandonment.
Did
I'm sorry.
did the membership interest move from the individuals that held it back into the company as treasury shares, which is what you indicate in your letter?
It's treasury shares. No one owns it. And there was no physical certificates to put in escrow. So it's not owned by any person, right? 5.110 and chapter 52 both refer to persons as a capital P, right? It's not owned by any person. It's owned by a company. And it's not actually, I mean, the company can't do anything with it. It's worthless until we get this approval.
But I understand all that. Our definition of person includes a limited liability company, which I read in my lead in. And
And
if
can you refer me to that point in the statute where it says,
this is let's see. NCCR 1.137 definition of person.
and it says, go ahead.
Person means a natural person, applicant, limited partnership, limited liability companies, and goes on for corporations and publicly traded corporations.
And is that a capital P?
I'm sorry?
Is that a capital P?
Yes.
Yeah. So under 5.110, it's not a capital P. And we discussed that before. It also says under 5.110, it says a transfer of an ownership interest in any amount in a cannabis establishment is not effective until the board has been notified on a form prescribed by the board of the intent to transfer an ownership interest in the cannabis establishment, and the board has found that each person, lowercase p, to whom an ownership interest is proposed to be transferred is individually qualified to be an owner of the cannabis establishment. So there's several issues in here, right? One, in terms of qualified to be an owner of a cannabis establishment. The cannabis establishment itself is qualified to be a cannabis establishment because it is a cannabis establishment. It's licensed. So, I am not trying to be difficult here. This exchange is exactly what happens to us every single time, right? I mean, there are matters of definition and of fact and of consequence in law and in tax that aren't relatable necessarily or always to lay interpretations of things. And so this is exactly the reason why I was forthcoming. This is a whole binder, a 6-inch binder worth of correspondence back and forth between us and production. We have nothing to hide. Nothing to hide. I never have. I think
Counsel,
Mr. Klimas
we
was,
note for the record that you have attempted to resolve this. And the parties have given you what they've given you. I guess at this point from the board, are there any other questions that any board member wishes to ask, either staff or Ms. Black? That might
This is
help.
this is Member Young. I had one question. I don't know if this would apply to Ms. Black or Chief Staley. And it's just in regards to Mr. Nielsen and his 20%. And then he abandoned that 20%, but I see on the new list that he's back on at 10%. So did he ever actually completely abandon and then come back, or was it just a redistribution, or did he have to reinvest in the company? I'm just trying to understand how that worked out. That he was abandoned, but yet he's still there.
thank you, Dr. Young. That's a good question. So this process has taken 12 months. And in that time, an agreement. So let's move back, I think, to Member Freilich's initial question, which related to litigation. So there was settlement under the litigation because the two leaving partners deemed that their causes of action under the litigation were more valuable than their membership was. And please keep in mind when you abandon membership, and please look at the definition of abandonment because nowhere in there does it say transfer. But when you abandon a membership, the tax consequences can be very beneficial because they are treated as capital losses. They're treated as ordinary loss instead of capital loss. And so, not that any attorney should ever discuss tax code because that's danger 101. But the long and the story of the tax consequence means that ordinary loss can be applied dollar for dollar against ordinary income. And a capital loss can only be applied dollar for dollar against capital gains. So when you abandon property, under Pilgrim's Pride case, and I think Revenue Code, it's 9380. When you abandon property, it's a much different tax consequence. So I do think in that sense, there was a value to abandoning, which is a business choice, right? That's one issue, but that doesn't have to do with any consideration that the company received. It's an abandonment, right? And once again, under abandonment, there is no definition for transfer. I mean, it doesn't include anywhere in there transfer. So that's one portion of this issue, of the myriad
Black, is
of
there a simple
issues.
answer to the question offered, whether or not
So,
with some consideration for the new 10%?
so what happened was that when both parties settled the lawsuit, one was paid in cash, one took back the note. That gave Polaris the opportunity to settle the lawsuit and circle up on a finite amount of damages. The one that was paid in cash is Robert. The one that was taken back on a note that they were going to pay off is Frederick. The note wasn't paid, and so Frederick has come back, and instead of sue us again, Frederick has come back in for membership, which has occurred because it's 15 months, and the market's bad. So that is the long, short answer to your question, Member Young. Thank you.
It's more of a comment, but it may elicit a response. I don't know that a title company would take this on.
They don't.
And it would never get back out. It would just be, they're so risk averse. They wouldn't know what's going on here. So I don't know that a title company was a viable option. Yeah, okay.
Any further questions from any board members to try to clarify? If not, does anyone wish to offer any kind of motion?
Chair Douglas, David Staley for the record. I would remind you they have requested waivers of Reg 5 as well when that motion is made.
Try a motion, Chair. It might not succeed. We might be doing another motion. Okay. I think staff did a great job here flagging that this settlement agreement could have been a way around the transfer rules. I just think in this case, it's not clear what to do in an abandonment, and because they were in communication with the agency the whole time, I don't think that they were attempting to commit fraud. If they hadn't been in touch the whole time, maybe they would. I do think we need to keep an eye on making sure that there aren't end runs around transfers, and I just don't think there's anything they could have done other than put this in their treasury stock. I don't think there's any other way to handle it. So I would move to approve the transfers of interest and leave it at that, and approve the requested waivers under 5.110 pursuant to 5.112 and 5.125 set to expire at the next TOI agenda date.
Anyone wishing to second that motion? If we have no second.
Member Guzman Freilich, second.
Motion, second discussion. I will say for the record, I'm not going to support it. I note for the record that one of the underlying things was so a party could make a true statement to a court of law in their pending child support. So there was intent to divest so they could make a true and correct statement to a court of law. I have a problem, but that's me. I have a problem. And I looked through it and we have manipulation. We had consideration, transfer. This is a regulated industry. I can't support it. I know there might have been a glitch. We're in correspondence. That's great. But the bottom line is no TOI request was submitted earlier when they divested or attempt to do so. Conversation, that's great. But that's just, if any other board member wishes to make a comment, please do so. If not, I'll call for the vote.
Mr. Chairman, we're having a hard time hearing you up here. Thank you.
Just the bottom line in terms of my feelings, we had transfers because a party wished to make sure they could testify on the record that they had no interest in a cannabis establishment. True and correct. So they were out of it. And so I'm not sure that we even come to how do you get to abandonment and then the legal proceedings and wrangling and getting back in. We never got a direct answer as to the 10% and the 20% difference and whether anything was actually paid or given consideration for payment, except, we settled a lawsuit. The question wasn't answered. So I'm not ready to support this motion. We have a motion, we have a second. Unless someone else wishes to weigh in, I'll call for the vote. All in favor of this?
Could I ask a question?
Please.
It's a question, it's not argument. Johnson's the one who had the child custody issue, not Nielsen, right? Okay, and when Johnson said, I don't want to have any interest, the argument would be this other case was settled and he got a settlement funds out of that, not that so he relinquished any interest and then got settlement funds, not any assets or
Remuneration.
anything like that or percentage. Okay, I just wanted to make sure that I wasn't getting that incorrect. Okay.
The question, going to your point was what was paid for the new 10% interest? Never got an answer. Correct, except
I'm sorry,
somebody
Chairman, can you
settled.
get closer to the microphone, please?
The question was whether or not what was paid for the 10%. And that was basically the answer we kind of got back. Well, that was a give and go within the settlement of the other lawsuits.
That's, Chair, that's incorrect.
Well, I'm just paraphrasing what you said
No, what I did
within
say,
that. So
sir,
what did you say?
what I did say, sir, was that Frederick took a note, right, to settle for the amount to settle the lawsuit. The note wasn't paid timely. So instead of reinstituting another lawsuit, they agreed that he would transfer some of the interest back. This just happened that he would take some of the interest back in satisfaction for the note that was to settle the lawsuit.
That's the 10% that he's getting?
Yes, sir.
I'll just leave it for the record. I'm opposed.
That one we would agree would be a transfer.
We have a motion on the floor. Voice in support of the motion.
Aye.
Aye. I oppose.
Let's go. I have an aye. I had a second. I have opposed. Member Durrett, what is your vote?
Aye.
Member Merritt, what is your vote?
No.
Member Freilich, what is your vote?
Aye.
And Dr. Young, what is your vote?
No.
And my vote is no, the motion does not carry. I would make a motion to approve the TOI, refer this back to a staff to see whether or not uh, working through the various arguments for this day, we can get a cleaner palette as to whether or not there is a violation, if there was a violation, whether there were sufficient mitigating circumstances to either make this a wash or minimal. But that's staff and able counsel for the litigant, Ms. Black, to do so. Hopefully it can be clarified. With the waiver of the conditions that were asked for as a 5110. That would be my motion.
And I would second that motion.
Been moved and seconded. Any additional discussion statements?
I guess I have a question for council, or let me think this through, because I would want to approve the transfer, and that's part of the motion, but I don't want to send it back to the for violation. So how would I? I'm just looking at all attorneys in the room.
You can
Okay, so
attempt to make a friendly amendment. I'm not going to accept that.
okay, and then so I would support the motion with the amendment, and then the amendment will die. So then yours would go through. Okay, I'm sorry.
So can I'll let you guys vote so then I can ask because I'm not. And you want me to go back and continue my healthy cooperation with Chief Staley?
Ms. Black, this is at this point, we're trying to make a motion, and in
Sorry.
some it would be we'd approve the TOI.
Mr. Chairman, we can't hear you.
Speaking to Council, Ms. Black, I'm saying what I'm proposing at this point is approving the TOI request is before the board this day, referring it back to see if we can deal with the issues that we're looking at one way or the other, whether in fact there is, whether or not on paper your position makes more sense than what's given to us. Even if it doesn't, whether there's sufficient mitigation to come up with some kind of resolution, or whether this has to go to full resolution. I don't know, but I'd like to see the staff hash it out, bring it back, or present it to us in another form, see where it goes. I'm sympathetic to the arguments, but I have some concerns based upon some of the facts in the real life situation. It's a problem. That's why they're lawyers and why they're courts. Unfortunately, we don't always agree. Now, having answered that, I have a motion, second.
So I would request to make an amendment that it be limited to just moving it, just requesting the transfer and not referring back to staff.
I'll deny that request. The question is whether or not the rest of the members of the support that, and they can do so. Saying no to what's on the table at this point.
Mr. Chair, could you restate your motion again, please?
The motion is to approve the TOI request and to refer the issue as to whether or not there was in fact a violation to staff for review to see if there's sufficient facts, or the mitigation should be viewed to give a downward departure as to any violation, whether or not, and if the parties can't agree, then the right to staff to come forward with a possible action. I don't know.
But the TOI.
Yes, sir.
Is there a second?
There was a second on the floor to the motion.
Okay, thank you.
Member Merritt, second.
And we note for the record that Member Durrett had made a friendly amendment, which I declined, basically would put us back to her original motion, which failed. So as to the new motion, all in favor, and Member Durrett, your vote?
Aye.
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 Aye. You're a nay or abstention?
I'm an aye. I support the transfer. That's what
Well,
I'm trying to figure out how to do. There's no way to parse it out.
No.
Okay, I'm getting that. I support the transfer, so
it
I'm an aye.
passes 5-1.
Thank you.
Congratulations on your transfer, and hopefully you can get some kind of resolution to this real world Gideon knot.
Thank
you
you
very
for your
much.
time. And I would like to thank
I do it procedurally.
Mrs. Prince and
I didn't
Mr.
mean to make
Staley
it
as well.
more complicated.
It's complicated. What the hell? We move to Mesa Oils, item C, TOI 22-00024, 22-00032, 22-00034, P073, RP073 for possible action.
Chair Douglas, members of the board, for the record, I'm David Staley. Item C are TOI applications by Mesa Oils LLC, which holds a production license in Henderson, Nevada. TOIs number 22-00024, 22-00032, and 22-00034 were filed to correct errors in reported ownership of RKA Investments LLC and for new transfers whereby ownership by George Patello and Harris Riddoff will be placed into various trusts for estate planning purposes. No areas of concern were identified during the investigation into this TOI application. I'm available for any questions, and my understanding is that Amanda Connor and Schloss are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Good morning, Chairman, members of the board. Amanda Connor for the record, and with me is Paul Schloss, who's one of the owners of Mesa Oils. We would kindly request approval of this transfer or the multiple transfers that are pending and the 5112 and 5125 waivers. We're happy to answer any questions.
Please.
Hi, Paul Schloss for Mesa Oils.
Ms. Scott, you have two with no concerns. What is this?
I'm sorry, Mr. Chairman. I can't hear you. Can you stay close to your microphone?
I'm sorry, my mic was muted. I just was laughing because she has two with no concerns this morning.
Yes, I'm turning over a new leaf, Chairman.
Chair, if I may, David Staley, Amanda, did you mention Reg 5 waivers?
Yes, we did submit waivers, I believe.
You don't have anybody qualify in your structure, and I don't see any waivers in here.
I can go pull my file, but I'm pretty sure they submitted waivers for.
If you have that, please. I don't have it in the report, and all of your members.
They are all currently above.
5 or above.
Yes.
So if you can find that, please, then we can amend the record to include that in this request.
Okay. Can I have a moment?
Go ahead.
I'm sorry, Chairman Douglas.
Chief Staley, it was with the submission on August 26th, 2022, I believe. Which was, I don't have the numbers in front of me, but was related to RKA Investments. So was the initial submission. The waivers were submitted with that. And I do have a copy here, printed copy, if you'd like to see it.
David Staley for the record. Ms. Connor, we'll review our documentation. I apologize for the oversight. What is can you state the reason for the waiver request on the record? And then I think we'll have all the components necessary to move forward right now rather than looking at it. Maybe
So the waiver request that I'm looking at was related to the members of RKA Investments. There are two members that hold 30% of RKA Investments, which holds 15 or proposed to hold 30%, which holds 15%. So I believe that was one waiver, and then there was the other waiver regarding transfers of less than 5%.
Thank you, Ms. Connor. And are the three members of RKA Investments passive?
Yes. They are not actively involved in the operations, and Mr. Sauce can state that for the record as well.
Thank you. Would you prefer that the waiver apply only to RKA or to the entire Mesa structure for future flexibility?
The request, I believe, is for the entire Mesa Oils for future flexibility, as there is also a request, I believe, for 5112 waiver.
Thank you, Chair Douglas. Based on Ms. Connor's representation, I think we have adequate information to move forward with a requested waiver of NCCR 5.2 and 5.125. I would request that, or I would suggest that you condition any potential approval that such waiver approval is scheduled to expire in their next TOI date.
I appreciate those comments. I would also further note that we would want them to report if the member of that subgroup takes an active participation instead of being passive.
Thank you, sir. Yes.
With having said that, we have a motion.
I have a question. How is Mr. Ridoff doing?
Member
say well.
Amanda Connor, for the record. Thank you, Member Durrett, for asking. As you may recall, last meeting he was unable to attend due to health issues. He is recovered and doing much better. He is actually on a flight to Vegas today, right now, and that's the reason he's not here.
Thanks.
Oh, with that, do we have any other questions?
I would move to approve. Dave, what are the suggested conditions? Are they approve the 5.110?
That was the position of approving those and destroying that the holder of that particular interest became other than passive.
Right.
They should immediately report to us.
Okay, so I would move to approve the conditions that the chair has stated and move to approve the transfer of interest.
Do we have a second?
This is Member Young. I'll second that.
Moved and seconded. Any additional discussion or questions? Hearing none, all in favor, please say aye.
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 Any nays, any abstentions? Hearing none, matter carries. Thank you very much for the cooperation.
Thank you,
Good
and
luck.
thank you to Investigator Mosley and Chief Investigator Staley and his staff.
I'm making matters a little lighter. Item D, MJ is off today. We passed for a month, and members of the board have been contacted for questions they might have so the licensee or the party's going to be prepared for the next meeting. That moves us to item number 7, request for consideration of approval of management service agreement.
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of Investigations for the CCD. I'm here to present agenda item number 7, which consists of one management services agreement, MSA. I had a brief update for the board on MSAs in general. On March 28th, 2023, at the board meeting, staff presented an MSA for approval between Premium Produce LLC and Albert Einstone's LLC. Counsel for the companies expressed concern that the MSA was actually only a licensing agreement and therefore did not appear to require approval. Earlier this year, Las Vegas Wellness and Compassion LLC submitted 3 MSAs for approval, but these MSAs included many characteristics of a sublease agreement, providing for the non-licensee to operate independently under the Las Vegas Wellness license. While addressing staff concerns regarding the nature of the MSAs, Las Vegas Wellness restructured the MSAs until they have become simple licensing agreements and do not appear to need approval. I'm bringing these agreements to the board's attention to note that they would have required approval as submitted, but now do not appear to need such approval, and to recognize the efforts of Las Vegas Wellness and its partners to address staff concerns regarding components of a sublease. Since these agreements no longer appear to need approval, staff proposes to send a letter to Las Vegas Wellness recognizing that the agreements have been included in our records and that in their current form do not appear to need approval. These letters will provide for Las Vegas Wellness and its partners to proceed with their licensing agreements, as well as provide a record of submission for our audit division to rely on as they review agreements during the review of licensee operations in the future. We will plan to follow this same procedure in the future with other submitted licensing agreements, unless the board has any questions or concerns.
The only concern I have is that at least they be put on the agenda as just consent items to apprise us. But you're correct based on discussions that have been had and positions taken by council. There's some licensing. There's simpler agreements. It doesn't change ownership, it doesn't change who's running companies and so on. But the board should just be on notice that that's correct. So if other board members have a question about that, state and staff can relook at it. It makes sense in terms of what was discussed, because now that we have the Cheech and Chong, the Willie Nelson, national that are coming in, things of that nature, it's a different ballgame. They're not running a company; they're just brands are being
Excuse me,
infused.
Chairman, can you repeat?
Their brands are being infused. I'm sorry.
Chair Douglas, David Staley, for the record, we will, unless we have other comments, we'll include that as an informational item and note that it's part of the database. I think Member Direct, you may have mentioned before, last agenda questioning whether those items are current record or when.
I'm sorry to interrupt again, but Mr. Staley, you're just cutting out every other word.
Oh, I'm sorry. David Staley for the record. Yes, Mr. Chairman, we'll do that. Member Durrett, this will give audit and inspection records to support their review of the licensees. I believe you mentioned you had a question regarding that at our last agenda.
Member Durrett, for the record, you're saying that these are going to go on the agenda going forward?
No, ma'am.
Okay. Would that potentially be a concern to the licensees who maybe they don't want to share all their agreements with the public? Not that some of these seem maybe proprietary.
We can.
Well, I guess I'm sorry. I would need to hear from the industry on that. I would be concerned for them that they would not want this ad hoc change to how their licensing agreements are handled. And I don't know what need we're filling here. So
I think what we're asking for is just notice of
every licensing agreement. There's
when you have people who are coming in and how this is being done, it will be being important for us to understand. At least they're in. Willie Nelson is in. Cheech and Chong is in. These nationals that are coming in. They're one product. They're not running the company. We don't. And your question is of process. How much do we need to know? Is it just notice, or is it? And that's what we need to sort out.
I have to defer to the chair because the chair sets the agenda. I very strongly feel we need to have that discussion in public, and formulate a policy discussion around it before we make decisions on looking at these, because I don't have all the information I would need licensees to illuminate that conversation.
Member Durrett and Chair, this is Tyler Climbers for the record. We're happy to do some due diligence on some statistics and some numbers to see what's out there, and that may help you understand the universe and may help guide the decision.
As well as you said, bringing the industry.
Thanks. Thank you.
Back to the agenda. We were on 7, request for consideration of approval of management service agreement. This is a little different, and you want to,
Chair Douglas, members of the board, for the record, David Staley. Item A is an MSA management services agreement between 5 Seed Investments LLC and BCC Nevada LLC, which provides for BCC Nevada to provide management and financing to 5 Seed in preparation for the submission of a transfer of interest wherein BCC Nevada plans to acquire 5 Seed. CCB staff have reviewed the agreement and found the relationship between the parties appropriate. I am available for any questions, and my understanding is that Rick and Jeanette Yabarian, Christopher Elliott, and Paul Larson are present today to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
for the record, Mr. Larson comes forward on behalf of the parties and the parties we have on screen. I just note my concern. I looked at the management agreement until I got to the very end, and I had to go back a second time. Operators shall receive compensation in the form of operators' retention of gross revenues, recognizing the obligation to pay the operating expenses of the business based on financial statements maintained by the operator. And basically, there was an agreement to pay rent and something else. So I'm a little concerned that this is out of the scope, even though there's a promise to put a TOI in place. So I have some concerns. The management agreements for an indefinite term. So I have a problem of a group coming in basically to run the damn business with no holds barred. We don't have a TOI in place. We know one's coming someplace, and this is indefinite. I'm willing just to put it all out there. I'm willing to support. I'd like more information today, but I'd like to keep this on a string to see what's happening, so to speak. It would be having it come back 6 months, 9 months to see if we're going forward. Otherwise, we need a full information about the people who are running this business, because it's not the owner anymore.
Mr. Chairman, for the record, Paul Larson representing BCC Nevada. We'd be okay with that. We plan to go full speed ahead on the TOI, and we'll be back in front of you sometime soon.
And understand, my concern is not as to the potential licensee of the party. Good people, I don't know. And they're trying to get in. They want to buy the business, from what I understand. It's a soft, spongy thing right now. And our obligation, if someone comes in, is really operating the business on a, we need to know who they are, what they're about.
May I address the board?
Yes, sir.
Hi, my name is Mark. Yeah, my name is Mark Forsberg. I'm counsel for 5 Seat. This is the, I guess, penultimate act in 5 Seat getting out of the cannabis industry. We do have a buyer, a qualified buyer. We have entered into this management services agreement. I don't think it has an unlimited scope. It can be terminated by the operator if the TOI is not progressing, and it automatically terminates when the TOI takes place, which the application is now in the process. If it hasn't been submitted, it will be within just a few days. So there's no question there. 5 Seat fully understands that it's still the licensee, that it has the obligations to keep the operation in compliance. Our understanding as well is that the buyer, BCC Nevada, is not going to grow. That's been 5 Seat's operation there has been as a cultivator, and that the buyer is instead going to be a production operation. And so there, at the present time, there is no activity taking place, and there probably won't if the TOI moves forward smartly. I hope that answers your questions. There are certainly limitations in this management services agreement as well that I think keep the obligations and the responsibilities on 5 Seat rather than shifting them to persons who are unknown to the board or unknown to the state at this time.
I thank you for that information. As I said, I noted under operating expenses, Article 7, Item B, operator and company shall enter into a lease for the real property and fixtures owned by the company which is used in connection with the operation of the business. That's the only compensation that's stated, and it's not fully stated. But having said that, you're moving in the direction that things need to go. And we've been tasked with certain responsibility of making sure we know who's in the business and who's not, or if you're providing purely service. So that's where the conundrum is.
And certainly, and I would also join Mr. Larson in saying that if that it would certainly be appropriate to, I think, approve the management services agreement today, and then place us on the agenda for a status
check.
Check at a future date. Yes.
Yeah, we'd stipulate to that.
Great. Thank you.
Other members of the board, and I know I kind of hijacked it to have questions.
Chair Douglas, for the record, David Staley. I do want to point out that staff does a background investigation of the managing entity, and we developed a level of comfort proposing that this relationship is appropriate. This is not full background and suitability we do that we include TOI, but through our review, we didn't identify any issues that preclude the management services agreement. It may be appropriate to potentially consider conditioning this approval that for a time certain for the and that would be met by the submission of a TOI application. And then at that point it would be in our queue. We'd be working on it if that worked for council.
If I understand that correctly, Mr. Chairman, you would be suggesting that if we file a TOI, would not come back for a status report?
David Staley, for the record, yes, sir. I'm proposing that we could consider a condition that the approval is conditioned to last 2 months or another amount, and that if the TOI is submitted, then that condition goes away.
That would be fine with 5C.
It would be fine with us as well.
Other questions by the board? I'll make the motion for the approval of the management services agreement, subject to providing a TOI request, and let's go 4 months on that. It sounds like they really want to be here to stay, so we're not going to push it, but just the concerns with how we deal with when a party basically is fully coming in to run it. We need to know what's going on. Otherwise, we get into problems and we get into the unforeseen nature of things that kind of we got into today, that things that we're supposed to know and we don't know. So to make it clear and to give parties ample time to get their business done without putting additional pressure on them to in the buy and sell process. So that would be my motion to approve the management service, give them 4-month period to get a TOI on the books.
Or come back for a status check.
Don't need a status check if the TOI is put forward.
Chair Douglas, for the record, David Staley. With the idea of a status check, I feel that could be redundant based on what the investigative agents will do. And that seems appropriate from us.
Member Drat, I second.
Been moved in second. Any other concerns, questions, or clarifications? Hearing none. All in favor, please say aye.
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 Aye. Any opposed? Any abstentions? Matter carries. Thank you, sir.
Thank you, Mr. Chairman. Thank you, board members.
Thank you, Mr. Chairman. Thank you to staff as well. Appreciate it.
Thank you, sir. Item 8, review of report of Governor's Office pursuant to Executive Order 2023-003 regarding review of regulations. No, we did not get our written report today. It's coming, but if Mr. Klimas has some education for us this morning and for the public.
Sure. Thank you, Chair. So staff is currently finalizing this report to satisfy the request of the executive order from the governor. As you know, we had that workshop on April 14th. We had great feedback, not only at the workshop, we had great feedback submitted after by members of the industry and stakeholders. And that was the purpose of this exercise. So certainly want to extend my thanks to those who did participate and provide feedback. A lot of the topics that were brought up were topics that staff had previously identified, topics that we had planned to hold workshops on and discuss. So it seems like we are aligned in ways that we can help streamline our NCCRs. The report that we will submit will likely include most, if not all, of the suggestions, because again, the suggestions are anywhere from changes to opportunities to strengthen or clarify. And I think a lot of what was brought up was thoughtful and falls into all those categories. So again, we look forward to submitting that report on Monday, but more so look forward to the additional workshops that we will plan to hold on things like laboratory testing standards, packaging, and labeling, among others. We will set those dates as part of the report. And again, my gratitude to those members of the industry who participated. And with that, Chair, I'm happy to answer any other questions that you or members of the board have.
What is the process for the board to weigh in on those items? Yes, for the board to weigh in on what's being going to be provided to the governor.
Sure. I mean, at this point, we plan to include all of the comments. Again, the request from the governor's office asks for, or given the input that an agency would receive during a workshop held pursuant to the executive order, that we identify any items ranging from changes to the regulations, repeals to the regulations, but opportunities to clarify or strengthen the regulations. So given the comments that we did receive that related specifically to the NCCRs, we feel like they're all, and they all will be incorporated in that report in their entirety, as well as context and summary from the individuals who provided public comment.
Questions or clarifications for other board members?
We will get to review it before it's submitted, correct?
That's correct.
And I'd like to have input on when those workshops are held. I mean, I don't get to schedule when they're held, but just input on, what needs to be heard more expediently than other things.
Certainly. Thank you.
With that being said, we move to item number 9, approval of resolution. Notice of final licensure A. We have Miller Farms, number 1, and number 2 is Natural Medicine.
Thank you, Chair, members of the board. Steve Gilbert for the record. Agenda 9A is an informational item presented as a notice to the board of establishments that have been issued their final license to operate. We have 2 licenses to note today. Miller Farms LLC was awarded a conditional cultivation license on April 11th, 2018, and a conditional adult use cultivation license on January 8th, 2019, both by the Department of Taxation within the Winnemucca jurisdiction. On February 22nd, 2023, staff conducted a pre-opening inspection and audit of the facility located in Winnemucca. The inspection and audit results revealed the facility was in compliance with NCCR and the NRS. A statement of no deficiency was issued on March 2nd, 2023, demonstrating that Miller Farms has met the regulatory operational requirements. And as a result, the CCB approved and issued final license to Miller Farms for its medical and adult use cultivation establishment on March 17th, 2023. Item number 2 is for Natural Medicine LLC,
to acquire distribution license T077 with the approval of TOI number C2200019 at the July 2022 CCB board meeting. On January 11th, 2023, staff conducted a pre-opening inspection and audit of the distribution facility located in the city of Las Vegas. The inspection and audit results revealed the facility was in compliance with the NCCR and NRS. A statement of no deficiency was issued on January 11th, 2023, demonstrating that natural medicine has met the regulatory operational requirements. And as a result, the CCB approved and issued final license to Natural Medicine for its adult use distribution establishment on March 17th, 2023. With that, Chair, members of the board, I'm happy to answer any questions.
Any questions by board members as to the two items that information was provided? Hearing number at item 10, brief chair, the director. I'll move it to the executive director primarily. Legislature, the first group of legislators, or House, the reps, have put forward some bills. We're waiting to see what's going to be done on the Senate side as to either bringing back some things as amendments from the dead and other things that are still alive. If they get through the first passages the next few days or exemptions. So it's cannabis is kind of an area of interest and disinterest, it seems, all at the same time. There's some fighting. I'll just leave it at that. Mr. Climate.
Do I have an option to leave it at that as well? Now we're up. The second deadline is today, so we'll see what gets through the second house. We've got a few bills that are exempt. We continue to track them. It has been interesting thus far, and certainly feel like it'll remain interesting for the remainder of the 40-some days that are left. Happy to answer any questions.
All right, our next meeting is May 23rd, 2023. Items for future agenda possibility. And Ms. Durrett voiced some concern or just the process for workshops and dates. So that for the record be looked at. Our second round of public comments at this time. Item 13.
Yeah. Good morning, Chairman, members of the board, Amanda Connor for the record. I know it wasn't on the agenda, but Investigator Staley did mention my client Premium Produce. And just to make the record clear, because I believe he stated it was a management service agreement, it was a licensing agreement that the board approved as a licensing agreement to the extent such approval was required. If I understood correctly what was being discussed, I would ask that a first workshop and formal rulemaking process be held regarding the process related to licensing agreements. There are hundreds out there, and if the process is now they need to be on an agenda, even consent for notice, I think the industry needs to be properly made aware of that change. Thank you.
Thank you.
This one's easy. I'm just going to say I agree with
State your
Amanda.
name just to-
Sorry, this is Tisha Black for the record. I'm just going to say I agree with Mrs. Connor that if we're going to start having to submit licensing, there's a lot of confidential information in there, things that have to do with proprietary business operations. And I think that the stakeholders in the licensee need to have ample opportunity to weigh in on that. Thank you.
Thank you.
Good morning. My name is Chandler Cooks. I'm just here to provide some feedback on the conversations I've had with community members and some other stakeholders who weren't present at the past CCB workshop. So these suggestions are just a few ways for the CCB to enrich communication with the community and foster a more inclusive and collaborative environment by incorporating alternative methods for people to attend and participate in upcoming CCB workshops. First, using more online tools for workshops. Online platforms such as Zoom webinars can help people join workshops who physically can't be present. And by accommodating virtual participation rather than just attendance, the CCB can stimulate a more diverse and representative discourse. I understand that Zoom has its risk with hacks and other technical exploits. However, hosting the meeting using a webinar-based platform can eliminate unnecessary interruptions and allow greater control over attendees. Second is a platform for communication feedback. The board should consider the establishment of an online forum or portal dedicated to the solicitation of community feedback on workshop content. Such platforms could include discussion boards or simply a dedicated email address for submitting questions and comments. And lastly, using social media to spread the word. Greater usage of social media could really augment the visibility of CCB workshops and expand the scope of your outreach. CCB is quite active on Twitter, but you haven't disseminated any information on your other social media accounts in nearly 60 days. The dissemination of key content through platforms such as Twitter, Instagram, Facebook, or LinkedIn can ensure the engagement of a wider demographic who may otherwise have been remained unaware. Thank you.
Additional public comment, Las Vegas.
Good morning. Excuse me. Good morning, Chair Douglas and members. For the record, my name is Timothy Eliado, representing Cora Lounge. And I just wanted to touch on the, I would just like to first start off by thanking Chair Douglas for stepping up as a leader by first acknowledging that the road to, I guess, all the pathway to, social equity or some sort of economic prosperity wasn't perfect. Prior to that, the board did not even want to acknowledge that there were favoritism and there were specific issues that needed to be addressed. So on our behalf, I would like to thank Chair Douglas for stepping up as a true leader and basically making that on record. And secondly, I would like to go on to say that we're here based on, I believe, Assembly Bill 341, not specifically on the social equity aspects of the conversation, in which the social equity language was included with AB 341. We're looking for a revision or a repeal, possibly, noting that specific language, unlike now we have, to be honest, for the record, that a lot of those decisions were done without legislative oversight. Now that we're moving forward, we would like to have all of that basically considered. We still have questions to the CCB in which haven't been addressed, and I feel like we have been ignored as applicants for social equity. I had previously emailed the CCB in which I had always received the same generic answers, basically to view for the lack of transparency within the whole lottery system, in which we're still seeking answers. For example, my application number was 105. The CCB had put up notification that I believe 100 applications were received and 99 applications were processed. My question is, why was my number 105? Why was number 100, 101, 102, 103, 104 before 105? The lack of transparency has been the problem. I don't stand here to disrespect anyone or be a problem or be a menace to society, because that is not my personality. The problem is, there is a problem. The legislature did not set forth the provisions in which this the social equity language would have been much more beneficial. Instead, as we know, they were granted by specific organizations, in which these specific organizations, and I could speak for one, Chandler, sitting right here. During the subcommittee sessions, right here, Chandler, each and every single time, CEIC, if that's the correct abbreviations, submitted an application, they informed you. Chandler stood right here. I submitted 3 applications today. Chandler never disclosed at any moment that he was an applicant. Chandler received a consumption lounge license. Being the dean, he proclaimed that he was the dean of students. Okay. During that whole process, I had consulted Commissioner Tick Sagerbloom due to the fact that each and every single time I reached out to this group for help, because that's what we were told, to reach out to CEIC for help. This is a test message I received from Commissioner Sagerbloom himself. I could read it out loud if you guys want to read to understand what's going on. There are some bad apples on the CCB. I'm not saying everyone is. You know who you are. Your term, 2025, some are not going to meet those terms. We, the people, are going to make sure of that. Thanks for your time.
Thank you. Anyone else in Las Vegas wish to be heard at this time? Anyone in Carson City wish to be heard at this time?
No comments, or no one here from in Northern Nevada.
With that, we are properly adjourned, and it is 11:24 and a half.